Although the Judicial Council made it relatively easy to ask requests for admissions by creating a fairly easy-to-use form, there is no corresponding form to respond. Fortunately, the responses are fairly simple as well. Your responses typically are on 28-line pleading paper. However, if they are otherwise in the proper format and on plain paper, that is acceptable as well, since they are not being filed with the court. Nonetheless, the templates that are provided with this presentation are in Word format on 28-line pleading paper. At the top of the form, print your name, address, and telephone number, and then, where it says defendant in pro per, if you're the defendant, leave it as is. Otherwise, if you're the plaintiff, change it to plaintiff in pro per. The name of the court typically goes on line 8. It has been moved to line 7 in the sample just to make it fit. Above the words plaintiffs, write the name of the plaintiff, where Acme Inc. appears, and replace Paul Sample for defendants with the name of the defendant. Replace the case number with your case number, and then change the title of the document to either defendant if you are the defendant, plaintiff if you're the plaintiff, your names, response to plaintiff if you're the defendant, or defendant if you're the plaintiff, their names, request for admissions, and then whatever set number is being asked, typically set 1. Below that, where it says propounding party, replace Acme Inc. with the name of the asking party and responding party with your name, and then write the set number again. And then below that, it will say responding party hereby answers propounding party's request for admissions, and then you create a number for each of the items that the other side is asking you to admit. So, although there are 3 examples shown here, if they ask 6 requests for admissions, you would add additional lines so that you would have 6 answers. Your first possible answer, if the other side asks you to admit that something is true, and it is true, is simply the word admit. By writing this, you are admitting that the fact they are stating is true. If the fact is not true, the answer is deny. It is possible, however, that part of the fact may appear to be true and part of it may be false, and you wish to provide some additional information. In that circumstance, you could either just deny it, or you could admit that part of it is true, however, deny that the rest or another part of it is true. So, for example, if the request read, admit that the accident that took place on July 5th, 2007 with the plaintiff was caused by your negligence, you could respond, admit that I was involved in an accident on July 5th, 2007 with the plaintiff, comma, however, deny that it was caused by my negligence. Finally, you have this answer. Cannot truthfully admit or deny the matter set forth in this request because he does not have knowledge of these matters, and despite reasonable inquiry into the matter, by reviewing all of the records and information available to him, to obtain information from which the truth or falsity of the matter might be learned. This answer means, simply put, I don't know, but I've looked through the evidence that I have, and I've asked around, and I still have no way of knowing. Your final type of response, assuming that you have not missed your time frame to respond, the 30 or 35 days that was previously discussed, you may object to a request. Common objections include that the request is impermissibly compound if it is asking for you to admit 2 or more different facts, that the request is vague, ambiguous, or unintelligible if it is impossible to determine what is being asked, that the request is not reasonably calculated to lead to the discovery of relevant admissible evidence. So, for example, if you were involved in a motor vehicle accident and the request were to read, admit that on the day of the accident you were wearing purple underwear, unless there is an allegation that your purple underwear somehow led to the accident, this request would not be reasonably calculated to lead to the discovery of relevant admissible evidence. There are many other objections that can be raised. However, there is not time during this presentation to discuss them all, and the supplemental materials listed at the end of the presentation will allow you to find books that will help you to identify them Finally, at the very bottom of the page, right above your signature line, you should have the language, "I declare under penalty of perjury under the laws of the state of California that the foregoing answers are true and correct." This is called a verification. When a witness takes a stand in court, the first thing that happens is the witness is sworn in. This is what transforms what the witness is saying from words coming out of his or her mouth to evidence that the court can consider. And this is the written equivalent of that. By declaring it under penalty of perjury under the laws of the state of California, your answers become evidence that the court can consider. If you fail to have this language, and therefore fail to verify your answers, it is considered the same as not responding at all, which would open you up to a motion to deem admissions as admitted. So be sure that your answers contain this language as well as your date and signature. Once you've completed your response to the request for admissions, make a copy to save, and then have the original served back on the responding party, courtesy copies served on each additional attorney in the case or self-represented party, along with a copy of the proof of service, and keep the original proof of service for yourself.